Welcome everybody to this special City Planning Committee meeting, the open portion for Wednesday the 2nd of December. We have a full composite of committee members. We have Alderman Briscoe, we have Councillor Harvey, we have Alderman Barakis, we have Councillor Dutta and Councillor Coates and myself.
Chair, I have to leave at 5:50. I apologise for that.
Thank you. Yeah. Thanks for letting us know. We'll try and get through the business as quickly as possible. There's item 1, there's no co-option to be had. Item 2 is indications of pecuniary conflicts of interest. I don't think you would have turned up if you had. Item 3 is reports. 3.1 is petition to amend Sealed Plan 1677-21 for 7 Montreval Rise. And we have a number of, well, we have the petitioner, obviously, but also those objecting to the petition. So, and one of them couldn't make it, so we're hearing from 1, 2, 3, 4 objectors. So I'll call to the table Chloe Rudkin and Stuart Gibson. Would you like to come up and address the committee, please, and we'll ask any questions. If you come to this table, thank you. Thank you very much, and we'll ask any questions if we have any after your presentation.
Okay.
Thank you.
Thanks very much for the opportunity to speak here today. I'll keep this pretty short. We submitted our letter on the 16th of November, and I just wanted to address points number 4 and points number 8 on our letter in respect to the petitioner's response. Points number 4 was the unacceptable increase in traffic, and the petitioner's response to that point, that there was no evidence being presented to the council to support such allegations. Again, further review of the proposal, I find that response quite hard to believe, that we have a 5-fold increase in car park spaces, which takes car parks to, I think, 10 in total, that there wouldn't be an unacceptable increase in traffic across the main access road. So I strongly disagree with the response and find it quite hard to believe that was a serious response. Point number 8 on the letter, our letter dated the 16th, in terms of the response with adversely affecting the value of the plot. The response was, no evidence has been presented to the council to support a reduction in value. The point I want to make here is we have anecdotal evidence that by having higher density developments in a low density planning scheme, that does adversely affect adjacent properties. There is research out there to support that, and what I would say to the petitioner is, you provide me evidence that supports your claim that it doesn't. That's all.
Okay, did you want to add anything?
No, that's everything. Thank you.
All right, thank you.
Thanks very much.
Does the committee have any, before you move off, does the committee have any questions? I think that was evidence in here as well. Okay, thank you.
Thank you. Thanks, Roger. Thank you.
I should have said that we're also doing a live stream of the meeting tonight, which is on YouTube. So, and that we have to wipe the surfaces as we go. I'll call to the table now Andrew Smith and Tracy Batt.
Thank you for allowing us to speak to this. We are one of the petitioners opposing the amendment to this covenant on the land. I guess really to reiterate the points that we put in, which was we bought this block of land with the ideal that we knew the covenant was in place, that it was limited to one dwelling per plot of land. To us, that was of huge value. You know, it provides a, you know, sort of scenic bush scenery within close living quarters of a metro area. To allow then to have a, you know, fourfold increase in the amount of dwellings on that plot of land, well, I guess you could consider that could open the door to all the other blocks of land also requesting such a rise in increase in the number of dwellings also, you know, which makes it exponentially, all of a sudden, instead of having 4 dwellings there, you've got, you know, 20 dwellings in this very steep land, piece of land. I guess the other main point is also in terms of the engineering of the block, which is an exceptionally steep slope. When we were putting in our own building application, we had to go through quite rigorous processes to get that approved with quite extensive engineering. We're yet to see that on the proposed development, and we cannot fathom how they can, you know, even build such a steep driveway and have such big amount of clearing and cut and fill actually logistically be performed on such a steep slope. You know, I'm not an engineer, but a logical person could see that this is not a smart development to have on such a steep slope. And the other point is that the covenant was put in there for a reason to begin with. We believe, our understanding is that the covenant asked the developer the council asked the developer for this covenant to be put in place in the first place, and there's obviously a reason for that. No developer would want to put that on their own land because it would automatically decrease their amount of buyers and, you know, potential value in that regard. So it's put on there for a reason. So I think we all have to remember what those reasons were. We are not privy to those reasons, but we can only, you know, assume that potentially it was because of the difficult building on the land and the engineering aspects that would go along with that. Thank you.
Thank you. Do you want to add anything else?
I guess I don't really have anything to add, but I've got a bit of a question of why was the development approved in the first place despite the covenant? To me, it seems like putting the cart before the horse. Maybe this should have been dealt with first.
Turner, would you like to answer that, please?
Yeah, certainly. Unfortunately, the position at law is that a covenant is not a relevant consideration when assessing an application under the provisions of the planning scheme.
Yep.
What you end up having is 2 planning instruments. You have covenants, which are private planning instruments, and you have the planning scheme. And the council or the planning authority, when determining a development application, can only have regard to the planning scheme and not to those private instruments that are contained within the schedule of easements.
And hence why we're seeing this petition, because it's a different form of legislation.
That's correct. Yeah.
Okay. Just in relation to the right of way, how will that affect you?
It won't affect our plot of land. No, our entry is prior to the right of way. So we are next door neighbours to the plot of land, but our access is separate to the right of way.
Yep. Okay. Thank you. Are there any further questions, Councillor Harvey? Then Councillor Dutta.
So what's your feeling here? You bought this land under the assumption that it would be one house per block.
Yeah.
Absolutely. And who? So I guess, do you feel a betrayal of the dealings with the sellers of the land? How do you feel?
I mean, it was clearly stipulated in the sale contract that these covenants were on the land. To then say, oh, well, the developer can take it off any time they please. Well, why did they put it on? Why were they made to if they can just take it away?
Mm-hmm. So without the covenant, would you have purchased your block?
I'm not sure.
We discussed.
You know, it was an attraction, the fact that it was got, you know, large blocks, you know, single living. We knew that they were difficult to develop blocks. As we saw, we found it very difficult to fit our one building into the building envelope. You know, so all of a sudden, yeah, it would definitely detract personal value, having a, you know, 4-fold increase into that block of land, and it would also be building right up against our boundary as well, whereas the expectation prior to that was that your neighbours would not be right up against your boundary, really.
And when we purchased the block, we did consider the covenant, knowing that it was generally going to be single dwellings on that land, because we have a son And we just thought, oh, well, this would be a nice setting for him to grow up without high density, particularly the traffic. That was a big issue there, so.
Quieter street.
Yeah.
And have any other blocks in that estate been subdivided at all? Or are they all single house lots?
One across has had 2 dwellings put on it eventually.
How did they manage that?
I think they were already starting to
Yeah, I think that was approved.
That was already approved beforehand, so we weren't really aware of that.
And I
when
don't
we
know if the
purchased.
covenant was on their block.
Yeah, I don't know if it was on their block. I think it's only on
Yeah, it's only on-
the steeper parts of the land. I think it's on.
Looks like.
Mm-hmm. Yep.
Thank you. Councillor Dato.
Thank you, Chair. Just two questions. Question number one, when you signed the contract, you had a clear understanding that there was going to be only one dwelling on that lot.
Yes.
The second question is, you also read clause number 9, which said that the rights of the vendor is that they would be able to modify, change, etc. You know, I think there were 4 elements in there from memory. Now, you read that and clearly understood that they had the right to do that.
I'm not a lawyer.
So I'm
I
just
would
asking a
hope that-
question when you read it.
To be honest, we signed that contract, 3-4 years ago. I can't recall, everything that we read at the time. I guess the spirit of it was that the covenant, was that it was limited to 1 block of land, 1 dwelling per block of land, and that was the spirit of what we signed.
Thank you.
Thank you. I don't think there are any further questions, so please resume your seats. Thank you. Okay, I will call now Mr. James Risby. Hello.
Thanks very much, Council, for the opportunity to speak. I'm the owner of the block of land immediately adjacent to the lot with the proposed covenant removal. When I purchased my block of land, I brought it with a clear understanding that the covenant was in place and in force and would continue to be in force. That was made clear to me by the real estate agent when I bought the block. That was also made clear to me in conversations with Ian McCormick, who was the developer of the Montreal Rise subdivision. I had numerous conversations with Ian McCormick, including by email, and I was assured that that was the case. On that basis, I went ahead and bought my block. When I bought my block, it was clear that any house I put on the block needed to be subject to good hill slope engineering practices, and so I engaged an architect, and we've made sure to design a house that conforms to good hill slope practice. Since doing that, I've been concerned about the stability of the Montreal Rise area. There is a lot of rockfall onto the road, both the private right-of-way at the top, which serves as the right-of-way for my block of land, as well as the council road down at the bottom. So there's ongoing rockfall on both of those and erosion, and large parts of some of those blocks of lands have eroded out, so it's an ongoing concern for me. The proposed amendment to allow 4 blocks on the lot next to mine, when you look at the footprint of those lots and you look at the excavation, it requires massive amounts of excavation on those lots, so large amounts of the soil is there. My architect made clear to me the more soil you remove from your lot, the less stable it is, and there's no commonsensical way that putting 4 houses there with all of that topsoil removal conforms to good hill slope engineering practice. So it seems to me that development just doesn't pass the LARP test on the rules that are applied to that development. I know that the petitioners have argued that the concerns we've raised are out of bounds for the various committees, but it seems to me that the council should have an obligation, despite whatever the letter of the law applies to each particular committee, to make sure that any development that makes it through its own set of processes arrives at the end of that in a manner that's consistent with what it would intend. And it seems to me that the proposed development is just not consistent with good hill slope practice on those lots. Furthermore, petition put forward is unfair in that it's intended only to apply to that one lot, not to the other lots. And in doing so, it ignores the arrangements set out in the covenant at the moment that there'd be an equal burden sharing plan of 1/5 for the 5 lots that adjoin that private right-of-way, and clearly that 1/5 share was based on the covenant specifying 1 dwelling per lot, so that there was an equal wear and tear on that private right-of-way, which we would all have a duty to maintain into the future. If you put 4 dwellings on a lot, obviously you multiply by 4 in general terms the wear and tear on that private way, but the petitioners made no attempt to address that unfair burden sharing in a petition as well. So that's a more minor concern. My major concern is about the modification of the hill slope environment and the violation of hill slope engineering. So I'm opposed to the removing the covenant.
Thank you. Any questions? Councillor Data?
Thank you, Chair. Just to clarify, you've said that there is going to be an unequal burden of distribution with regards to contribution to the road and the wear and tear. If that was included in, would you then accept it?
No, I wouldn't, because that's a secondary concern. My major concern is the wholesale excavation of soil off that site renders that site unstable on a block that's already badly eroding, or the whole set of blocks are subject to ongoing erosion, and I urge the committee to visit the sites if you haven't done so already.
And just one more question. With regards to the fact when you bought the land, did you seek legal advice with regards to the contract you were signing?
Of course, I engaged a conveyancer when I bought the land, so all my purchase went through a conveyancer.
Councillor Harvey?
It was a similar question, whether you had legal advice with regard to the covenant, but your own feelings towards the covenant. Could you just explain those again? How much confidence did you have in the covenant that you wouldn't be in a situation like this?
Well, I was in full confidence. I had no realisation that the covenant could be removed in this way. And I had, as I said earlier, I had multiple conversations with Ian McCormick, who developed the original subdivision, and Ian led me to believe also that covenant was strict and not negotiable.
Did he give you anything in writing with regard to the covenant? Or it was just part of the contract for the land?
He didn't give me anything in writing, but that was verbal communication.
Okay, thank you very much.
Could we just have some clarification, not from the representative, just the covenant is actually on the title, would that be correct? Yeah, so the legal practitioner for any land transfer would have access to that covenant. You wouldn't have to ask for it, it would be part of the title.
Yes,
yeah.
it's on part of the schedule of easements.
Thank you. Okay, is it Lewis or Louis? Louis, Elson and Bryony? Bryony Elson? Thank you.
Thank you for having us here to speak. A lot of our concerns mirror what's already been discussed here, but I guess I'll briefly go through them again. We live at 13 Montreval Rise, which shares the right-of-way. We were aware of the covenant, along with a bunch of other covenants that were on there, and that was definitely an influence in our decision to purchase the block. I know that the point has been made that this was written that it could be removed by the person that placed the covenant. However, given the fact that it was requested by the council to have this covenant placed on, that's what we spoke to Ian McCormack about the reason for it specifically. He specifically told us that he was requested to put this covenant on by the council. And as such, we feel like at the very least we should be given an explanation as for the reasoning behind that in the first place. As has been mentioned already, we have our beliefs that it is related to the stability of the ground there. We can't find any written reasoning as to why it was asked to be put on, but that makes it a little bit of a different situation when you're saying, oh, you should have known that the person that put it on can just take it off when they want. But when it wasn't their actual request to put it on, which is backed up by the fact that what sensible developer would choose to put on covenants unnecessarily, I think we really need to sort of get to the bottom of that before we can sort of just say, oh, if he wants to take it off, he can take it off. Because it did influence our decision and all of the other people that have represented themselves here. And I think that's kind of like a key factor which we can't skim over the top of. Do you have anything you want to add?
A couple of extra things, as noted by a couple other people. There's been some significant rock falls there. There's one behind the wire mesh as you first come up Montrevail Rise, and the rocks have actually fallen down under the wire mesh. I've contacted the council quite a number of times and no one's looked at it or responded to me. I know the council has been up there before to clean the rocks up off the public road area, which has been great. But I suppose my concern is if there's going to be a bigger development there and there's going to be more rock falls and they're going to impact on houses lower down, and we can't get the council to respond to that issue or that risk by remediating it, that's an issue to me. Second issue is further to the reasoning for the covenant being imposed. There was geotechnical advice when it went to tribunal from an expert engineer that said it's a landslip risk area, even though if you look on this map it's not identified as a landslip area. Further up the hill is. I think the evidence of the rock falls since the subdivision's been developed, and we've had a couple of really large rain events which has made it worse. The cyclone fence is falling down because the dirt's eroded, so those extra security measures are going to fail, and we've got no mechanism, from what I can see, to get that addressed, and this development will potentially further exacerbate it. There's also the issue of firefighting. If you actually drive up Montrevail Rise, yes, the hydrant is within the 90 metres of being able to supply a dwelling, but the topography of the land doesn't actually enable you to use that hydrant to put any fires out at those developments. That development has taken up pretty much the whole block, and from the planning application that we've seen, I can't see there being sufficient space to have tanks there to fight fires. So that's a real risk. That's a risk to adjoining properties as well, and being close to the bush. So they're the extra points I wanted to make.
And actually, if I could just add one more thing, just to explain the relevance of why we're talking about this landslip stuff, because I know there'll be a tendency of people to go, oh, that was covered in the planning, so it's irrelevant. But I think it is relevant when we look at it in the context of we're trying to figure out why this covenant was placed on at the request of the council in the first place. And this seems to be the most logical reason that it was there. That's the reason for why the covenant was there. The reason why we object so strongly is because it has influenced what the whole vibe up there is, that it was going to be a low density blocks on steep slopes, single blocks. That was the understanding everybody had, and now that seems to have just gone out the window.
And on poles as well, like not substantial retaining walls with cut and fill, further placing load on that already fairly unstable weathered dolerite.
Thank you. So just to start, to make sure where that the cyclone fencing and the rock fall is located, is that on the other side of the road from where you?
We're at number 13, and the cyclone fence extends from 13 along. I get mixed up with the lots and the numbers, but number 7. Sorry, no.
9
lot 9. So the 3 properties. So the development that we're talking about today, and the one in between us and the development, and the cyclone fence, you can just see the concrete and there's no dirt around it in the road frontage for lot 11.
On the top side of the public road.
Yeah, that's a much better.
And So you haven't really talked about traffic or the implication, because it's very steep around, coming around your side of, or the side of your block, which is really surrounded on most sides, isn't it, by the road. Could you just explain what concerns you have in relation to traffic and
yeah, well, as
right of way?
mentioned earlier on, the increase in traffic will be significant, effectively doubling the amount of traffic going up that area already, which once again, aside from whether we did question a lot of this when we went through the planning process as well, and about whether the road was even designed to that level. We were told that it was, in which case that's great, but even the fact that, we have multiple cars, the chances of cars passing themselves significantly increase on a steep hairpin bend. The question is, was that road designed for the intent that it now is facing? And I don't believe it was.
Okay. Any further questions? Councillor Coates.
Thanks. Just to get it on the record, reading, and look, it's only been a week, so I suspect the answer is no, but you refer here to having submitted a right to information request. I take it that hasn't formally come back as yet? No? Okay, cool. Thank you.
Yes, a week's very
Not a very
short
long time to get
isn't
one of
it?
those three. I know, yeah, as a reading, I thought I might.
Councillor Dutton?
Thank you. Just need some clarification on the statement that was made, that the covenant was placed at the request of the council. Can I have some clarification on that, please?
Yes. We have done our research and haven't been able to identify that it was placed at the request of council. If it was, it would seem to be unusual, because ordinarily covenants that are required by council have to be entered in with council, so that council has the right to enforce it. And ordinarily, where covenants are placed on a title, council would not then allow somebody else the power to waive or modify that covenant. The only power would rest with council to do that. So we'd have to do a little bit more research to definitively answer whether or not it was at the request of council, but it would be surprising given our past requirements for covenants.
Yes, Chair, so for me that is an important element that I want to look at later, and if clarification can be given, I would appreciate. Thank you.
Thank you. Any further questions? You did put in representations in relation to the application, did you? Did you put in representations in relation to the development application, against the development application?
Yes. Yes.
Yeah.
Yeah, we all...
Yeah. I thought so. Right. Okay. Thank you. Please take a seat. Thank you. So we aren't hearing from Ms Naomi Edwards as an objector, so we now hear from the petitioner, or Mr Alex Cordova, on behalf of Immobilier Development Proprietary Limited. So, Alex, would you like to come to the table, please?
Thank you, Madam Chair, for the committee to hearing this matter. Perhaps I may start by saying that submissions have been filed in respect to the petition application, and responses have also been filed responding to the objections made to council in relation to the petition. And I will not add too much to my submissions already filed, but perhaps I'll respond to some of the comments made by the objectors today to the committee. To start off with, just to clarify a few points in relation to their objections, and also I note that some of the committee have asked those questions and addressed those topics already. But perhaps the first thing that I would like to address is the assertion that the council requested for the covenant to be placed or registered on the sealed plan. It is my understanding that that's not the case at all, and that the vendor and original subdividers were the people or the company who placed and registered that covenant in the sealed plan. It was not a request by council. And I should note that if you refer to the planning decision made by the Hobart City Council, which is attached to my submissions at paragraph 4.2, it makes clear that this covenant, amongst others, is placed on the title by the original vendor and not by council.
Has anybody got that page number, just to make it easier for us to get to that?
Of course. So it's page number 7 of the council decision.
Page 143, thank you. Of our report, thank you.
Was it 143, Chair?
Yes.
Thank you.
Sorry, go ahead, Mr. Cordova.
So paragraph number 4.2 makes it quite clear that the covenant was placed on the sealed plan by the original vendor. The second matter which was submitted to the council was that they relied upon the covenant when purchasing the land. Now, as it was rightly pointed out, just two clauses below the covenant, there's a right of the vendor and original subdivider to remove that covenant. And if those objectors obtain legal advice in relation to that title when sealed plan and the contract of sale, a competent legal advisor would have advised them that there was risks in relation to the vendor in site management removing that covenant. And such rights in Tasmania are allowed, and there's a decision of the Supreme Court saying that it is allowed that the vendors reserve their rights to remove covenants in sealed plans. I should also point out the fact that some of the objections say that they relied upon verbal advice from the developer or third party or the council. The petitioner and the applicants are bona fide in relation to any verbal agreement that the objectors had with other parties, and therefore it cannot be penalised for any verbal agreement that those people had or any inducement, misrepresentation that was made to them by other third parties without the knowledge of the applicant. Therefore, if the objectors have any issue in relation to those misrepresentation and advice they receive from council potentially, or the subdivider or original vendor, they should take action against them for misrepresentation or some other action after seeking legal advice, and my client should not be penalised for that. Lastly, and one further issue that I think the most important issue is that if the objectors also objected to the planning application which was lodged to the Hobart City Council, and after the permit was issued and approval of the planning application was obtained, they had 21 days to appeal to the Resource Management Appeal Tribunal if they had any concerns in relation to the decision of the council about the permit issued and the approval of the application. It is my understanding that none of the objectors have made a planning appeal application to the council if they had any basis for appealing that decision. When assessing a planning application, council takes a lot of care in considering a lot of aspects of the application, including the right-of-way, traffic, any issues about engineering issues with land, any landslip risks, and things of the kind. And it is all good for me to, from the bar table or from this table, make submissions to the council about those things, where the appropriate mechanism would have been to make the appeal application to the Resource Management Appeal Tribunal, obtain expert evidence in support of their objections, and go that way with a view of trying to reverse the decision of the Hobart City Council in relation to the issuing of the permit. Now, if you look at the permit that was issued to my clients in relation to the 4 dwellings that they wish to build on the property, you'll see that the permit has a number of conditions which have to be satisfied for them to build those dwellings at the block. And of course, my clients as the developers will oblige to those conditions and make sure that they are in accordance with the permit which was issued by council. And lastly, I just would like to make one thing clear, is that given Clause 9 granting powers to the original vendor and subdivider to waive or remove or amend the covenant, and given that my clients have entered to an agreement with the original vendor by way of a deed of modification, which has been included in the submissions, and also a consent form, legally speaking, it is my submission that irrespective of the sealed plan being amended or not, according to the Supreme Court decision of Clark and Buddy City Council, my clients already have a right to not rely or rely upon the amendment of the restrictive covenant. And the petition to council is simply for the sealed plan to actually be amended to reflect that. And the advantages of amending the sealed plan, of course, is future disputes, because is all well and good my clients having the consent of the original subdivider and owner by way of a deed, a legal deed, and also consent form, and having the sealed plan is still showing a restrictive covenant in the plan. This opened the book for further disputes, including injunctions filed at the Supreme Court, which of course will be opposed, but the reason the application and petition is so important, in my view, is so the actual sealed plan reflects my client's now legal rights in respect to the right-of-way. Now, putting that aside, I see that the most valid point on the of the objections received today are in relation to the shared responsibility of the right-of-way. I believe it's unreasonable for my client to have 4 dwellings and only contributing 1/5 of the cost of maintaining the right-of-way. And for that reason, I believe it is important that issue be rectified. However, in my view, that issue should be rectified by private agreement between the petitioner and the other objectors to this petition, and come to an agreement as to an amendment of the sealed plan and a separate application to council by all of them together, seeking that that part of the sealed plan be amended.
You were to ask a question now,
Yes.
Alderman Briscoe?
That was your last point, wasn't it?
It was.
Yes. So,
Yes, go
yes,
ahead.
yes. I understand the point that the vendor had this covenant where you could actually change any element of the covenant, 1 to 5. But I imagine when you purchase from the vendor, actually it'd be attractive to say, oh yes, I'm buying a block which all the surrounding blocks will only have one dwelling on it. So what you're saying essentially is people bought these blocks knowing the covenant looked like it was protecting the amenity of the surrounding block, and then once they were sold, you changed the rules. So it is therefore not attractive. Now, to me, just reading through the other parts of that covenant, there seems like quite minor things, yet, and no one reading through that probably would think that changing the number of dwellings per lot would be changed ever. Mm-hmm. The other thing is not to have a transportable home. You could change that. You could have a transportable home, but to have a major, it's like a condition of sale in my view, and therefore, what's the point of the covenant?
Yeah, I understand where you're coming from.
Yes.
So the same issue, and exactly your point,
yes,
was dealt with by the Supreme Court in a case called Clark and Burnie City Council. Exactly the same issue where there was a covenant on the registered civil plan, refraining the owner of that block to only building one single dwelling on that block. However, there was also a right of the vendor or original subdivider to remove that, and that was legal and found to be legal.
Yes, even though it was unfair.
Even though it was unfair, and I should also always, of course, unfair is a tricky term to define and very subjective. But what I should know is that if there was a covenant with no right of the vendor or original subdivider to remove that covenant, of course, the position of my client will be quite different, and we would be on an uphill battle here. However, that's not the case. The case is that the blocks were purchased knowing full well that there was a right of the vendor and original subdivider to remove those covenants by agreement. And that's legal, and it's found by the Supreme Court of Tasmania to be completely fine.
In one case?
That was only one case decided on this, and was the Chief Justice Bloy that decided to make the decision.
Yeah. Thank you.
Thank you, Chair. Three. Just two questions for the moment. First one being, do you know, or do you have any sort of understanding of what the intent of putting that covenant on the what the intent of putting that covenant in what was? Because there was a bit of talk about whether it was the council's idea to do it and what the reasoning for it was. Do you have any understanding of what the intent for the covenant in the first place was?
Yeah, it's a good question. Unfortunately, I don't, and the reason I don't is because I don't act for the original subdivider or vendor. I act for a purchaser of the block who relied upon that section. So, unfortunately, that's a question to be asked to the original vendor and subdivider, and unfortunately, I cannot answer that question.
Secondly, there was a bit of talk about the risk or the effects that this might have on the stability of the ground. Can you respond to that at all?
I can. So the stability of the ground was an aspect considered by the Hobart City Council in the planning decision. If you look at the decision and the planning permits, you see that there's a number of engineering reports and geological reports which were considered by council when coming to the decision to issue the permit. Otherwise, council would just say that unfortunately the building of 4 dwellings in this block is unsafe and dangerous, and therefore we will not accept or approve that planning application. So that's basically my answer.
Councillor Data.
Thank you, Chair. Just a few questions. I quite understand where you're coming from and your legal position in this whole matter. Question number one, in issue 1, you mentioned that the assertion was made that this was a request of the council, and it was your understanding. So is it still your understanding but not any evidence to substantiate that understanding?
It is my understanding, by looking at the decision of the Hobart City Council, which before making those comments in their decision about the planning application, I'm aware they probably did some research and found out that the covenant was registered by the original vendor and not by council. And that's written in the Hobart City Council's decision for the planning application.
Okay, and so therefore it is on that you're having that understanding?
Correct.
All right, thank you. Question, your issue number 2, with regards to contract you talked about, and correct me if I'm wrong, is it true that in contract you can have both a written and a verbal contract?
Correct.
Okay, thank
correct.
you.
Yeah.
Issue number 3, with regards to the appeal process, you mentioned that there was no appeal made. Now, do you think that the appeal wasn't made because the depth and the extent of the impact and the understanding of the facts wasn't very clear? Or do you think it was an oversight, that's why it wasn't appealed?
I unfortunately cannot comment about that, and perhaps that's something you should ask the objectors. Not
Yeah, but you think naturally these things can happen? In the natural sequence of
my
events?
understanding is that if you object to a planning application, Hobart City Council will send you a letter which clearly states that you have 21 days to appeal and you should seek legal advice. And I assume, and I'm quite certain, that Hobart City Council provided those objectors to the planning application such letter and put them on notice of the appeal period. And notwithstanding that, they also have a way of applying for an extension of the time frame.
And the final question, with regards to issue number 3 in your submission, you said that the dependent here for the rights of your client was clause number 9 and had the right to modify, etc., etc.
Correct.
Now, when the purchaser bought that land, do you think that that particular clause was seen as not being modified, but something else would have modified? That could have been an interpretation?
It's really hard for me to answer those questions because they are more questions directed to the objections and the people who made those objections. What I can say though is that if you are buying a property and it's such a big investment for yourself and your family and your future, you obtain legal advice in relation to the effect of entering into the contract of sale would have and the risks of entering into the contract of sale. Now, if you wish to sign a contract without obtaining legal advice, you know full well of the risks that you could be taking.
And just one final comment. You referred to the Supreme Court case. Are you aware of a High Court case on this matter?
No, and the reason that it is hard to find a High Court case on this matter is because the law in different states vary in terms of removing restrictive covenants. For example, in Victoria, the threshold is very high, but of course, in Tasmania is a matter of discretion. But luckily, now in Tasmania, we have a decision which was made back in 2008, which now I expect and assume is being referred to other local government to make decisions of this kind.
Thank you, Chair.
Alderman Briscoe?
Yes, look, sadly in a moment I have to go, but my colleagues here will make the decision. But all I can say is, could I just go through a scenario? If the original vendor died, and so the vendor no longer exists, then these rights would be set in stone, wouldn't they? And it's only because you've got some kind of funny assignment from the vendor to your client that these live on.
First of all, the vendor here is a company, is not a person.
Oh, well, let's say the legal entity. Yeah.
So the legal entity, you say the company is registered. The company is the registered?
Yes.
Correct. So that's a very good point, and I'm sure there's a lot of cases on this point, but I haven't considered those cases, so I can't provide you with that an answer to a question. If the company was registered, and in this case, the company is not registered, so.
So at a point in time, say if it was deregistered, then whatever the restrictive covenants that's in place at that time would have to stay?
Not necessarily. Depends what the law says about that.
Yeah. Well,
yeah.
Okay.
I don't see why is it relevant to this particular scenario.
I was just trying to understand how your client got the right of the vendor to change the original covenant.
My client got the right of the vendor to change the original covenant.
To remove that. Is your client the vendor?
No, my client is the owner of the land.
Right.
The vendor is a third party who has nothing to do with me.
Yeah, but how did your client get the right to vary?
My client relied upon the clause in the sealed plan, contacted the vendor and entered into an agreement, and the vendor, which every person from lots 8, 9 and 10 can do, and got their permission for that covenant to be amended.
Okay,
Yes.
thank you. Have we got a copy of that?
Of course, you have a copy.
All right, okay, thank you.
It is a little confusing. there are lots of twists and turns relating to all of this information. Councillor Harvey, you have a question?
Yes, so Mr Cordova, clause 7, how do you interpret that to us of the covenant?
Clause 7 is the clause which we are talking about today, and that clause restricts the use of the right-of-way. And if you look at the plan, there's two right-of-ways. There's the A refer to A and also B, and the interpretation of that clause basically says that one dwelling per lot can utilise that right-of-way for access to their block. So if, for example, you have 4 dwellings in your lot, then of course that would not work because you will not have right of way or access to those dwellings.
So the intent of 7 was to prevent multiple dwellings on one lot.
It could arguably it could be. However, in these circumstances, of course, there was discretion on the subdivider and vendor to remove that if he was of the opinion that that was not the case.
So clause 7 is overridden by clause 9.
If you obtain the agreement of the original owner, correct. Oh, and of course, I should note that it's not overridden, but there needs to be either an amendment to that. There's a right of amendment, so you can request the original subdivider and vendor a right to amend that clause in a certain way that would benefit you. If the vendor agrees to that amendment, he has a right to agree to that.
Alderman Barakis.
Thank you, Jen. Just to follow on from the previous question, in regards to clause 9, covenant 9, as far as the right to modify, vary, waiver, etc. From the legal perspective, when we talk about the word the right to, what does that mean as far as the vendor's responsibilities and rights in this instance?
Of course. So it's a really good question. So just because a covenant is removed, it does not mean that a person can go there and build 4 dwellings. So if, let's say that the permit and the planning application had not been lodged, and my client obtained the permission of the vendor and subdivider to remove that covenant. The covenant is removed, and then my client has a duty to go to the local government, which is how the Hobart City Council, and make a planning application in respect to the building of 4 dwellings. So there's 2 stages here. It's not just because the covenant is removed doesn't mean my client's able and can and has permission to build 4 dwellings in the property, because that's not how it works. The covenant is removed, and then you have to go through the planning application, and the council, relying upon the planning scheme, can make a decision whether to allow that planning application or not. So there's 2 aspects to it. So that perhaps answers your question.
So I suppose just to be a bit more, just to narrow it down a bit more, from the wording of Part 9, effectively, is what the covenant's saying is that the vendor, if they so wish, have the ability to strike off
and anything like that.
And that's not I suppose prefaced on any other qualifying factors. They've just got the right to do that.
Cordova, do you know if anybody else who has any of these lots has considered putting in more than one dwelling?
No, no, Chair. I'm not aware.
Your client is just this one person?
Yeah, my client's one. I believe is a quite recent subdivision, and there's a lot of vacant blocks at the moment around that area. I note that it was mentioned earlier in this hearing that there was a further subdivision down the road, but it wasn't sharing the same right of way. But I'm not aware, unfortunately, of any further applications.
And you can you understand why the objectors have considerable concerns if they were expecting that there would be one dwelling, since they're part of these the lots that we're talking about as well, and part of, you know, they've bought into Montreal Rise, so you can understand how upset they might be.
Of course.
Can you just consider other reasons why somebody mightn't take something to the tribunal as well? You know, so you're talking about, well, this wasn't the development application, the approval wasn't challenged, but what other considerations might there be?
So, of course, in relation to appealing a decision of the Hobart City Council, it is recommended legal advice, of course, and obtaining reports and going through that litigation process, as I call, it is expensive. It is expensive, emotionally taxing. However, my view is that if you feel that something is not done right, or they have failed to consider a part of this important application, I feel that legal advice should be obtained in any event. However, I understand where you're coming from about it is not...
can be prohibited.
It can be hard, yeah.
Thank you. All right. Are there any further questions? No, and I think we need some clarification from Ms Turner as well. So thank you. If you'd like to take your seat again. Now, committee, we have... Ms Turner, do we hear this? We have the right to hear this now or in closed, and presumably we would want to hear this in the open. Is that right? Do we have the choice of making the decision now? Do we?
Yes, you do have the choice of making the decision now, or alternatively you can defer it.
Right. Okay. Thank you. All right. So I'll open the item for discussion. Councillor Dutta.
Chair, in the light of what I've heard and some of the information and facts that are missing for me to make the decision, I would recommend that we defer this decision. And the question that I want to also ask, is there a legal advice given to us on this matter?
I think we do have legal advice,
right,
but we also have advice, independent advice, which is enclosed. Do you want to answer that?
Yes, through you, Chair. Yes, we have obtained some legal advice with respect to the impact of the Supreme Court decision that was referred to by the petitioner's representative, and that has been provided to you under separate cover.
Discussion. I'm not going to take that deferral motion because I think if there is potential to discuss and we're making a recommendation to full council, so it will be heard. It will be the decision will be made by council on Monday.
Chair, could I get an explanation of how the vendor performs with this? The vendor, being the company that developed the estate, gives consent to amend the covenants or to annul the covenants or to whatever the other options were.
That's because of the way that the covenant is written. It does reserve the right to the vendor to modify, vary, waiver or extinguish the covenant, so they've reserved that right to them to do that. And the legal advice that council has obtained is consistent with what the petitioner's representative has said, is that there is a right to do that in Tasmania. Notwithstanding it may seem unfair, but there is a right to do that, and the Supreme Court has clearly indicated that that is appropriate in all the circumstances.
But the vendor could have said no.
The vendor could have said no.
But the vendor, the company who originally put the covenants on the titles, has then said, well, I've left them open so that the covenant's useless. So how does that get through the process? It seems unethical to some degree.
So, covenants that are in... So there's two types of covenants. There's obviously covenants with council, and certainly we don't ordinarily, where council is requiring a covenant to be entered into with itself, reserve the right to vary or modify. However, private covenants aren't subject really to the scrutiny of council. Our surveying team will give them a little bit of a once-over to say, is there anything outrageous here that shouldn't be there? But provided that they look to be in order, then that's a matter for the vendor. If they want to impose conditions on their blocks that they then intend to sell, that's a matter for them.
But they're also able to revisit it and take away the covenant.
That's correct, yes.
And is that the case with all these other blocks as well? So every block mentioned or every lot could potentially ask for the same benefit?
So this particular covenant applies to lots 8, 9 and 10. So yes, lots 8, 9 and 10 could seek to have that covenant vary, waived, modified or extinguished.
Alderman Baraka.
Thank you, Jen. Just through you, I want to, not so much a question, I just want to clarify my understanding of the situation. There was a lot of sort of concerns raised that I think were valid concerns, but they seemed like very specific planning issues. Given that this is related to a previously approved DA, that has, I'm just, my understanding of what the situation is, that's largely been, I don't know if resolve is the right word, but we're not looking so much as the planning, we're not really operating as a planning authority, we're only looking as to whether or not we're formalising or agreeing to the amending of the covenant. Is that correct?
That's correct. So what you are considering tonight is whether or not to amend the sealed plan in accordance with the petition. Whilst a planning permit has been issued, there's nothing to say that the holder of that permit has to act upon that in the event that council does or does not grant the petition. It's equally feasible that they could go get another permit for a different development.
So this is effectively completely separate from the DA itself?
They are separate.
In a sense. Yeah.
I mean, the application is something that you could consider, and it might be a relevant factor in your decision making, but it wouldn't be determinative of you determining whether or not to grant the petition or not.
Are we discussing, or are we just asking questions at the moment?
What?
I'm asking you. Okay, look, I think
there's any standing
orders. I think, look.
Just as a committee, yeah.
Not wanting to, people had questions.
Yes, I think so, yeah.
Okay, yeah, look. I think, given that there were some pretty legitimate concerns that were raised from the planning perspective, I think especially the geological issues. But once again, I think they were largely covered in the DA. And would have been covered off by council, but B, I think it's effectively a separate issue. I think there's we kind of have to look at the legal precedents here and what the law's told us, unless anyone here are lawyers. But if it's a legitimate statement to say that people bought these blocks under the impression that the clause is being proposed to be amended, was part of the covenant, and that was part of the reasons why they bought their blocks. If clause 7 was a legitimate, the expectation that that's going to be a covenant, then there also needs to be the expectation that clause 9 is just as legitimate of a covenant in there as well, which gave not the ability of the vendor to request that the covenant be amended, but that they've got the right for the covenant to be amended. And I think if we're looking at it purely from that legal standpoint, I think if they've got the right to do it, and that's been backed up by law in previous instances, I think we have to follow through with that. And if that's similar to what the legal advisor said, that we have to, they've got a right to do that. I think there's not much that we can really do in this sort of instance as far as making the right decision. I think the only right thing to do would be to allow it. And once again, they might not be seen as being fair, but I think from a legal standpoint, we have to be careful about the decisions we're making as well. I think that's something that we really need to consider strongly.
Well, yes, I mean, I'd like to hear from you, Ms Turner, because, I mean, is it a must that we have to follow the decision, which, you know, we've obviously got advice from Mr McElwain, and it says in the last part of this that it's provided the vendor, in this case, the relevant factor to be taken into account, but what weight the council gives to it is a matter for its overall consideration.
So that's right, is that the fact that the vendor has already agreed to waive that that covenant isn't determinative of your decision making. You could still refuse it. What the position at law following Clark and Burnie City Council is that is what the petitioner's representative said, is that in fact the petitioner could go and do what they want to do without us council amending the sealed plan, because they have that waiver from the original developer already. What they want to do, as I understand it, is the petitioner wants to formalise it so that it's on paper, everybody knows, so that there can't be arguments later down the track that they may have breached that.
So we're just talking about signing it off and making it legit, but in the scheme of things, is whether or not the development gets built or not, it might not really make a difference.
That's correct.
But look, I'll stand by what I said, but I won't stand in the way of deferral either. I think it's a hairy one, and it might benefit us to get some more advice.
And just another question. So would it be up to the petitioner, should we refuse this, to take it further to court?
Well, there's always a right of judicial review against a decision of this nature.
Mm-hmm.
That would obviously be a matter for the petitioner. Equally, if you refuse it, as Mr Cordova pointed out, the petitioner could go and do it in any event because they've got the waiver that's been granted by the developer.
But possibly that might be appealed by somebody else.
That can't be appealed, but as Mr Cordova pointed out, what could happen is if they go to do the development, potentially somebody could go to the Supreme Court seeking an injunction because alleging that they're in breach of the covenant. Clearly, Mr Cordova's clients would produce the waiver and say, well, we've got a legitimate waiver under Clause 9 of those covenants.
Mm-hmm. Okay, thank you. Councillor Harvey?
I think that answered my question. So this is all a farce. So the covenants have no bearing whatsoever. The developer, the petitioner, can go ahead and build the 4 units anyway because he already has a waiver. So why are we making a decision? And so if we make a decision to say if we refuse that the amendment be refused, they can go ahead anyway. It's extraordinary.
Council was obviously served with a petition asking that we determine an amendment to a sealed plan, so we have to follow the legislative process. But that is correct, that the petitioner could, in reliance of the waiver, undertake their development in any event.
And they have a permit already to build 4 dwellings, and they could just get on with it.
They need to get. I don't believe they've got building or plumbing approval yet. Mr Cordova is nodding, so maybe they do or they don't. They don't, no. So they would still need to get their building and plumbing permits and obviously comply with all the conditions of their planning permit. But the covenant would not stand in the way of them undertaking that development.
So, through you, Chair, is this a lesson for the future that the council needs to come up with, I don't know, some sort of regulatory framework that makes covenants real if they're going to be on titles?
Yeah, covenants are certainly a difficult area. They sit uncomfortably with a planning scheme because often covenants conflict with the planning scheme or things have changed. From a legal perspective, I certainly don't like covenants because they're a purported private instrument trying to control development. You know, you see covenants about height or number of dwellings on a site and the planning scheme has a different control. So there does need to be better mechanisms with respect to covenants on title. that is probably regulatory reform.
Because otherwise they're used as a method of selling something. So there might not have been such enthusiasm for purchasing blocks of land if people had realised that the covenants aren't worth the paper they're written on.
Councillor Coates?
I guess I'll preference this for the purpose of discussion, and thank you all for listening in. The elephant in the room might be that, from my reading, this may or may not in some way, shape or form end up before court. But I guess I have a question through you, Chair, but obviously we heard, having read through the objector submissions, and there was concerns raised tonight in regards to the value of our land and amenity and all those sort of issues. And obviously part of that contract they all entered into was to burden share the cost of actually maintaining that right of way. And we also heard from the proponent tonight that they are actually willing to go down a path of seeking to get a private agreement so that could be amended and changed. And look, if at the end of the day the courts say they're entitled to build these units and the planning scheme says they're entitled to build these units and they don't have a covenant because it's been waived blocking them from building these units, they probably will be able to build these units. The fair and just outcome may not have been that, because I think these people legitimately bought blocks of land under the good knowledge of reading their contracts that there was a clause in there saying one dwelling. Be that as it may, is there any capacity for us if we were to, and look, this might be something for defer, obviously the decision's on Monday, but to put in stipulations around actually providing compensation or providing recourse for that? I know it's on C, but I'm concerned about the ongoing maintenance cost for the road. I mean, I take them at their good word that they are going to enter into negotiation, but
we can have that clause.
That might happen or may not happen in 6 months. Is there capacity for us to actually say, look, you actually do need to enter into that?
You can make the amendment with or without modification. So in my view, your modification could extend to modifying the sharing arrangement that's in the schedule of easements to change that.
Okay, cool. That's good.
Alderman Barakis.
Thank you. And I suppose that was a good point, and that triggered my next question. In regards to the recommendation, or the part 3, let me just get to the right page, about, where are we?
Part C.
Yeah, sorry, part C. That we, any person who benefits from the amendment is to make compensation in money or land to the person who's injured by it. Could that potentially place the objectors or those that are suggesting that they'd be negatively affected by this in a better position than if we were to refuse this and they were going to build the development anyway? Because that wouldn't leave them any, they'd have to potentially go to the courts to get any recourse there. Does this kind of open them up to getting some sort of compensation if they are adversely affected?
There is options for council to order compensation be paid. It would have to be quantified. In the directions that we issued with respect to this hearing, we did request that any person who wished to make a claim for compensation notify all the parties and council with full particulars in writing by the 23rd of November, and we didn't receive any claim for compensation.
Oh, so does that make part C kind of moot in that regard then?
We could still have that clause, couldn't we?
Yeah, so as far as awarding a party a monetary sum to compensate them for any loss that they claim they may be suffered, we haven't received a claim and we have no particulars of it, so it would be difficult to make a decision in those terms. However, yes, you could amend the clause about how the maintenance burden is shared.
I see that potentially as a win-win, especially if, as Councillor Harvey eloquently said, it's a bit of a farce if it kind of doesn't make any difference one way or another. If we can approve it but add some stipulations on there, we can make it as close to a win-win as possible. If the development's going to go ahead regardless, would be my take. But at the same time, I think this is a hairy one, so I'd be leaning towards supporting Councillor Dutton's wish to defer this so we can get some more information on this and make the same decision
Yep. So just in relation to, thank you, just in relation to the information that we require, which makes up this deferral, is it drafting that clause? Is there other information that you required, Councillor Data?
I asked the question, Chair, with regards to the legal advice, and I haven't read that. Maybe it was there. So I haven't read that legal advice that was given to us, that's all.
Yes, it was part of the documentation.
All right, okay.
Yes,
no, it came too late and I had other commitments, so I'm sorry about that.
So we can either make a decision or we can defer to a special before council. Or we could take a vote now and...
Chair, could I suggest with regard, we do it separately, because I think Part C, require a condition making the amendment that any person who benefits the amendment is to make compensation in money or land to a person who is injured by. I would be happy to suggest that we accept something like equal shares towards the maintenance for all dwellings. So there's 4 plus 5, so we've got 9, so it would be 1/9 per dwelling. Is that something we could consider? Just to get the ball rolling?
We could consider. Through you, Chair, what I would recommend is perhaps asking Mr Cordova to provide some written submissions to us as to what he suggests would be appropriate. That could be to the other parties as well, so they're included in that, so there might be consensus before it comes back to council.
Mm-hmm.
That is certainly the way we have done it in the past, where we've sought to make amendments through a petition to a sealed plan hearing.
So are you suggesting that you put that...
Well, if it would be better coming from the parties rather than from us.
No, I'm asking whether you wanted to move...
Well, I would move...
Subject.
Well, for me, if that's part of the deferral, but if I was voting now, I would vote that the amendment be refused. That's how I would vote if I was voting now.
Be refused. Right,
yeah.
okay. Thank you. Councillor Dutta?
Just a point there, Chair. You know, because this is, as Alderman Barakas has said, there are two separate issues. One is a development issue, that is not the issue here today. The issue for me that I'm looking at is more a legal issue. So I don't want to be making a decision or bringing in clause in the run, as it were. I would rather, especially if it's to do with legal matter, that we look at it properly. Otherwise, you know, you are accountable to a decision that you have made without that information.
So you're moving...
Could I clarify? So you're talking about the legal advice we have. You'd like to have that. Like to discuss that further. And
even the suggestion you're making, you know, it would be better to what has been responded to, that the parties are involved and we get something, and therefore.
Okay. So you move for a deferral subject to formulating a clause which involves parties objecting and the petitioner. Okay. All right, I'll move that motion for deferral. Those in favour? Aye. Those against? Items carried unanimously. So that will come to a special before council on Monday, and Ms Turner will be in contact now or over the course of the week. Thank you. So does that now close the meeting? So the meeting's now closed. Thank you very much for your attendance.